This is another yes or no question. Can Pueblo consider regulating any type of abortion care or abortion service under RIA?
Yes.
That's all.
Well, why don't you explain that further, Mr. Craddock?
So the answer is yes. RIA, as a state law, preempts local ordinances, right, as a general rule. But that same is true of federal law as to state law, right? Article 6 of our U.S. Constitution says that the federal Constitution and the laws of the United States are supreme over state law. So if our state law is broader than what is permissible under federal law, then the state law is preempted to that extent. So for example, federal law prohibits partial birth abortions. If RIA were read to be so broad, protect a right to abortion so broad as to allow partial birth abortions, that would be nullified, and this council would be perfectly justified in passing an ordinance ensuring that partial birth abortions are not permitted, consistent with federal law.
You know, the Attorney General, Phil Weiser, who is the highest legal authority in the state of Colorado, why do you think he would disagree with you?
Oh, that's a great question, and I'm glad you asked. I reviewed Phil Weiser's letter, and it's incomplete because he fails to consider how federal law is supreme over RIA to the extent they are inconsistent. So he gets an incomplete grade on that letter, and he's doing it for political purposes.
I could say the same thing about your testimony.
I'm not an elected official. I'm not an elected official who gets donations from Planned Parenthood. I'm not an elected official who gets donations from Planned Parenthood. That's right. And so there's several federal laws that would be applicable here. Of course, there's the partial birth abortion ban, which was the one that, Warren Hearn was saying, am I violating it by doing these late-term abortions? He was asking that in a published article in Salon, was it Slate or Salon magazine, right? And so that's one federal law that could be at issue. And state law can't create a right to abortion that's broader than what federal law allows. The second aspect of this is actually federal law that prohibits the interstate shipment and carriage of abortion pills and devices across state lines through the Postal Service, across state lines through common carriers like DHL or FedEx, or through the U.S. Postal Service, anywhere. And so that's a federal law that, an ordinance here in Pueblo could address and say, hey, look, in Pueblo, we're just establishing that in Pueblo we're going to follow federal law. There's no inconsistency there between state law and the local ordinance. And if there were, the state law would have to bend in favor of the federal law.
Mr. Gifford, our own city attorney that represents the city and this council, what's your legal opinion? Do you think that would federal law trump state law?
What we're referring to is the Comstock Act, I believe, of 1873, which was amended in 1972 or 73 to prohibit the mailing of abortion services in Texas. And I'm not meaning to be glib. I'm not meaning to be glib. This is something that's very serious, and I think everyone has a serious opinion on this. So until I'm presented with something that states otherwise, I don't think that we would be wise to pass this ordinance.
Thank you.
Mr. Craddock.
Yeah, thank you, Mr. Gifford, for that intervention. I want to add that on the Comstock Act, which is 18 U.S.C. 1461, 1462, it's been around for about 150 years. But it was most recently amended and revised by Congress and President Clinton in 1996 to actually expand 1462's application to interactive computer services, making it illegal to use the internet to ship or receive abortifacients. And actually, Section 1461 continues to be included in the most recent edition of the U.S. Post Office's Publication 52, which states that any article or instrument designed, adapted, or intended for producing abortion is non-mailable. So I understand that the Attorney General, Merrick Garland, has issued, the Office of Legal Counsel has issued an interpretation of what this Comstock Act means. But, courts have yet to weigh in on this in full. One judge of the Fifth Circuit, U.S. Court of Appeals for the Fifth Circuit, has opined that this law is still fully enacted. And in fact, there were questions about this before the Supreme Court, where at least 2 Supreme Court justices have indicated their position, suggesting that the Attorney General's interpretation of this law might be misguided. So I think it's hardly a settled case that just because the OLC issued an opinion giving this an extraordinarily narrow interpretation, that is the last word. My final comment is that to the extent 1461 and 1462 mean what Attorney General Garland said in the OLC opinion, then there would be no conflict between federal law and state law, and thus no conflict between state law and the ordinance. So either way, this council has authority to pass such an ordinance, because either there is a conflict with state law and federal law trumps, right? Or there is no conflict with state law whatsoever, because there's no conflict with between state and federal law.
I guess this is just more me being curious. If what you're saying is true and federal law trumps state law, why haven't you sued the state over RIA?
Well, so to be clear, there's right now you have to have a cause of action to sue, and so what the ordinance would be providing a private cause of action, for example, to private citizens to bring a civil suit for enforcement to ensure that federal law is followed in the within Pueblo. Right? So because to sue, you have to have what's called a cause of action, like some legal right granting you authority to sue. And so that's actually what the ordinance would allow, to ensure that federal law is being followed.
Perhaps no other Colorado community, though, has implemented this because they know that RIA protects any sort of municipality from regulating any type of abortion service.
Well, I don't think that's the case, because the ordinance itself is, again, as I explained, the RIA cannot preempt the ordinance if the ordinance is consistent with federal law, right? Because federal law trumps state law. And so to the extent that there is any inconsistency between federal law and state law, they can't preempt the ordinance.